Hello everybody, hi. I wanted to do a quick video today about something that I kind of found particularly fascinating. Today a document was filed, today on December 13th of 2016, a document was filed by an interested third party, basically, in Brendan's case. Um, they are filing what's called amicus curiae, or in this case, because they are multiple parties, it is a amici curiae. And what that means is that amicus would be if it's one. The fact that there are multiple parties doing this, that it becomes amici, just to clear that up. Anyways, they are bringing this motion to the court. They're in this document that you're seeing right here. They are actually, this is part of them asking permission to be able to file their motion with the court. And it's interesting. They're just kind of, it's a real brief kind of hitting the main points they want to talk about. I just find this totally fascinating that, because this entity, these three entities, the Juvenile Law Center, the firm of Wicklander, Zawalski and Associates Inc., and Professor Brandon L. Garrett, all together are pooling their information and making this motion. So in their initial layout here, they're just saying that those three parties share a common interest in ensuring the full range of constitutional protections that they are afforded to children subject to interrogation to ensure their confessions are voluntary. Amici share a concern that validating Brendan Dassey's confession will undermine crucial Fifth Amendment protection well established by law and rooted in social science, will fly in the face of the best practices in law enforcement, and ultimately will undermine the truth-seeking function that proper interrogations fulfill. Alright everybody, so here's the really good bit. This is probably the best bit here. Love it. Okay, so what do we got? The police policies and training materials make clear that Brendan's interrogation placed undue coercion on him, putting him at risk of false confession. Due in large part to notoriety garnered by the Making a Murderer documentary on Netflix, Brendan's interrogation has been under much public scrutiny. Certified interrogation specialists have used the video footage of Brendan's interrogation as the proverbial what not to do in training courses, and pointed to the officers' practices to demonstrate the impropriety of Brendan's coercion, or interrogation. The impropriety of Brendan's interrogation. So that is just awesome. Totally putting it right out there, saying that is looked to, that Brendan's interrogation is looked to as a what not to do when training interrogators. That speaks volumes. It truly speaks volumes. So that's why I say that was the best bit, because, man, very powerful point, very, very substantial, and it's awesome. So here's just some more, points that they're making, things that they want to make the court aware of. The interrogation failed to adequately account for juvenile status or intellectual disability as recommended by police policy, training, and practice materials. The International Association of Chiefs of Police and the Office of Juvenile Justice and Delinquency Protection both recommend that when interrogating youth, police should take additional steps to verify comprehension of legal rights and should use less coercive interrogation methods. Wicklander and Zawalski's interrogation training materials further clarify that the interrogator of a youth suspect must be constantly aware of the unique position of power that he holds. The child learns what is expected and what is positively reinforced, and his interrogator adult, or from his interrogator adult. David E. Zawalski and Douglas E. Wicklander, practical aspects of interview and interrogation. The training notes that a suggestible youth may incorporate the information given by the interrogator into his memory, blurring the line between reality and fiction. Seeking to be compliant, the youth may also avoid confrontation and give in more quickly, knowing that he will receive positive reinforcement for answering the interrogator's questions despite the veracity of his response. So they're basically applying here that Wiegert and Fassbender were basically being very nice to him and very cordial and very positively reinforcing Brendan when he was saying things that were incriminating him. But when Brendan tried to say it wasn't me, or was saying something they didn't want, he was, then he needed to stop lying and blah blah blah. Anyways, we all know this saying, almost song and dance, nothing new under the sun. Alright, so here we have them making further point about the tactics used on Brendan. Brendan's interrogation was also suspect because of the numerous threats and promises made during the course of the questioning. Law enforcement is trained to never make promises or suggest leniency when questioning. WZ training course at Chapter 6. As the district court explained, more than merely assuring Dassey that he would not be punished if he admitted participating in the offense, the investigators suggested to Dassey that he would be punished if he did not tell the truth. So, I mean, and he was constantly being badgered in that way, back and forth that whole time. I mean, he was worked over the coals. He was raked over the coals. I mean, poor kid. So, youth with disabilities are particularly vulnerable to police pressure and false confessions. The Supreme Court has also recognized that individuals with disabilities are uniquely susceptible to coercion during police interrogation. Thus, a suspect's youth, his subnormal intelligence, and his lack of previous experience with police make it impossible to equate his powers of resistance to overwhelming police tactics. So, I mean, that's touching on the fact that Brendan really was kind of a fish out of water. He didn't know what was really going on at that point in time. I don't think he understood a lot of what was being said to him. I think he felt like he was reassured that if he told them what they wanted, that he was going to be able to go back to school and not miss WrestleMania. So, it's unfortunate. But anyways, I just wanted to do this video about this motion that was filed. I just found it fascinating, where a third party was able to file a motion mainly just because of the fact that they have expertise in this subject. Anyways, this subject, it's what they do. It's what they do. It's part of their, it's what they're constantly doing every day is their job. It's something they know. And so that's why they're able to file. There's 3 different types of stipulations that allow someone to file amicus or amici. Amicus or amici curiae. Anyway, so I just found it fascinating. These people are experts, very well respected, and so they've basically weighed in on this, and they're really mainly worried about the fact that if this decision, if Brendan's confession is upheld, the implications it's going to mean for all the the Fifth Amendment rights that they're already trying to protect, and the stuff that's going on out there to ensure that juveniles give voluntary confessions, and what it takes to make sure that happens. And so got to have a lot of respect for these guys. Anyways, guys, that's it for this video. We'll obviously be back for the next video, but if you haven't already, please hit subscribe, and we'll talk to you guys later.